everyone, it's Jim Filippi with the Filippi Law Firm. Today we're going to discuss everything that you need to know about estate planning. To make this super easy for you, I'm going to break it up into different sections. First, we're going to discuss what a revocable living trust is. Then, we're going to discuss what a pour-over will is and how it works in conjunction with a trust. After that, we're going to discuss both the general durable power of attorney and the California statutory form power of attorney. And finally, we're going to discuss the healthcare documents, which include the HIPAA Authorization and the California Healthcare Directive. So you must be asking yourself, what is an estate plan and why do I need one? But before we go over that, I wanted to take a step back and discuss the history of an estate plan. You might find this strange, but estate plans have gone all the way back to the times of the Babylon. And fast forward into the English common law, people did estate planning to deal with the transfer of land, whether it was to someone in their family or to a caretaker who had been working the land over a number of years. And it also dealt with the transfer of businesses. Businesses were held in a number of different families, and the question always was whether it was going back to the government or if it was going to transfer to another family member. Which brings us to today. We're going to talk today first about the revocable living trust. Now, a trust is used to transfer property just like a will does, but it does so outside the supervision of the court. This is important because court supervision tends to make things more expensive and take a lot more time. A trust will help you avoid probate and thus save you the time and the money of going through the probate process. A revocable living trust has tremendous amount of flexibility. It can be used to transfer one's assets, to help you avoid taxes, possibly avoid creditor liabilities, and it could live on either in a short period of time or a long period of time if it was going to take care of a charity. A revocable living trust also allows you to plan for the possibility of government-based benefits, especially when you are married and a spouse is going to leave their assets to you. Now you must be asking yourself, what are asset-based government benefits? You've probably heard of Medicaid, or if you live in California, Medi-Cal. To qualify for that program, you can only have a certain number of assets. If you go over that amount of assets, then you no longer qualify, or you have to deplete those assets before you qualify again. So with proper estate planning, you can make sure that assets from a spouse go into a separate trust that are held there for supplemental or special needs that may be required, but are held outside of your estate and won't be qualifying under your estate for those asset-based government benefits. Ultimately, a revocable living trust serves to distribute your assets and allow you to control the use of those assets long after your death. This can be very beneficial for you if you have minor children, a dependent adult, or even one of those fiscally irresponsible adults. The next section we're going to discuss is the pour-over will. Now you may be asking yourself, why are we calling this the pour-over will? It's actually really simple. If for some reason you forget to retitle an asset into the trust, the will catch that asset and pour that back into the will. It's kind of like when you have that sewing machine that you want to give to your granddaughter, or the baseball collection you want to give to a nephew, and you didn't sign a document or something was wrong with it, and it just didn't happen to fall into the trust. We can give instructions to the court to pour those assets back into the trust so that the trust will be the instruction given to disperse those to the proper people. The pour-over will also acts in case the trust itself is defective. The trust can be defective in a number of ways. There could be an error that was done in the signatures, in the drafting, or a change in the law. Now, what the will do is say that even though the trust is no longer active, we're going to incorporate the terms of the trust into the will through our reference that we put in the will. And if that fails, we give instructions to your executor to create an entirely new trust using the same exact terms of the old existing trust. We use those features so that if anything happens to the trust, or an asset falls outside of the trust, we ensure that the trust that we've drafted for you and that you took the time to customize operates is going to distribute the estate assets in the instructions that you provided. The next section we're going to discuss is the general durable power of attorney. Now, this document is used for when you've become incapacitated either through illness or injury and you're no longer able to make the decisions that you need to make on your behalf. This is where you've designated someone to step into your shoes so that they can manage your affairs during your period of incapacity. The benefit here is that if something did happen to you and it's during a certain period of time, you will not come into a bunch of collections notices or foreclosures or eviction notice after you've recovered. You'll walk back into your life and know that everything was taken care of during your illness or injury. It's very powerful because it also helps you avoid conservatorship. This is the same type of power that one would go to the court to have powers granted to them to act on your behalf. So this helps you avoid the process of going through conservatorship and obviously the cost and time involved in doing that. The next section we're going to discuss is the California Statutory Form Power of Attorney. Now, this document is very similar to the general durable power of attorney we just discussed. However, it's more readily recognizable for those that work at financial institutions and other places like that. When they see that general durable power of attorney, they oftentimes want to have it reviewed by their legal department and will make your power of attorney wait that time period for that review. The important thing with this is that you walk in with both the general durable power of attorney and the California statutory form power of attorney with both documents. The hope there is that there won't be any delays in making sure that your affairs are taken care of when your power of attorney needs to act. We're now going to move into the healthcare document portion. In this next section, we're going to discuss the HIPAA authorization. Now, if you've ever been into a doctor's office, you've probably seen HIPAA plastered all over their office. And HIPAA is quite easy. We all know that our medical information is private and protected by HIPAA from disclosure unless you've given authorization. Now, it's implicit in the name. The HIPAA authorization gives that authorization to those people you designate so that they can receive your medical information and make the decisions they need to make on your behalf when you're not able to make your own healthcare decisions. And finally, in our last section, we're going to discuss the Advanced Healthcare Directive. You may have heard of this document referred to as a healthcare power of attorney, a living will, but in California, we call it an Advanced Healthcare Directive. And what it does is the same thing as those other type of documents. It gives the authority to someone that you've designated to make healthcare decisions on your behalf when you're not able to do so. And it also gives them some instructions on how to make those decisions for you. That's important because significant decisions are often tough to make, like continuing medical care when there's no hope of survival. That is a very difficult decision for someone that's close to you to make, not only during an emotional experience, that's when you're going through a medical situation, but also wondering what it is that you would want to have happen. You take that stress off of their shoulders by giving instructions in your healthcare directive that allows them to make the decisions that you wanted to have made. Okay, so let's review. We've discussed 6 sections. We've discussed the Revocable Living Trust, which gives those instructions on how to disperse your assets. We discussed the Pourable Will, which is that safety net for the Revocable Living Trust. Then we discussed the General Power of Attorney and the California Statutory Power of Attorney that gives someone authorization to manage your affairs if you're incapacitated or ill. And then finally, we discussed the healthcare documents, the HIPAA authorization, and the Advanced Healthcare Directive, which gives people the authorization to make those decisions for you and to receive your medical information as well. And so that is an estate plan in a nutshell. I really truly hoped it helped you understand what an estate plan truly is and what is contained in a comprehensive estate plan if you're looking to establish one. If you have any questions whatsoever, please feel free to leave them in the comments below, and we will answer those in future videos. I hope this was helpful to you, and I look forward to seeing you again in one of our future videos. Take care.